Eric Katz. Thomas Casey.
Thank you. And Mr. Walter, right?
Yes.
Thank you.
I'll leave it.
Please remain seated, come to order. Good morning, folks. Welcome to Department 2. So I'll call the matter of the Morro Bay Commercial Fishermen's Organization versus California State Lands Commission et al. And I've been informed that we have a court reporter remotely. So I do see that. I think Madam Clerk also talked about the fact that the government code requires the court reporter to be present in court for an official record. So I wanted just to reiterate that. But I will ask for folks to state their appearances at this time.
Yes, Your Honor. William Walter.
I'm sorry, I could not hear that. And good morning, Your Honor.
Good morning. So Mr. Walter, if you don't mind,
Yeah,
there you go.
sorry. There we go. William Walter, on behalf of the petitioners and plaintiffs.
Morning, Your Honor. Thomas Kinzinger here for California Coastal Commission and State Lands Commission.
Good morning, Your Honor. Eric Katz for the State Water Resources Control Board.
Okay. Did anybody else wish to state their appearances at this time? Thank you. I understand that you folks are the ones that are going to be making the arguments. If other folks who are on Zoom want to state their appearances, I can give you that opportunity at this time.
Thank you, Your Honor. This is Alicia Winterswike of Best and Krieger, appearing on behalf of Atlas Wind, aka Equinor, Real Party in Interest.
Good morning, Your Honor. This is Joseph Trapolsky with Norton Rose Fulbright US LLP, and I'm appearing on behalf of Invenergy California Offshore LLC.
Good morning, Your Honor. This is Julie Jones of Perkins Coie LLC, here on behalf of Real Party in Interest, Golden State Wind.
Good morning, Your Honor. This is Alina Shamas from Burke Williams and Sorensen on behalf of CSA Ocean Sciences, a Real Party in Interest.
Good morning, Your Honor. This is Sahar Durali, Deputy Attorney General, appearing on behalf of California Coastal Commission and State Lands Commission.
All right. Thank you, counsel. So just to give you folks some parameters, we are going to need to complete the arguments this morning. I have a jury coming back at 1:30 this afternoon. And the order I'd like to handle these in is to start with the Coastal Commission arguments first, and then the State Water Resources Control Board arguments on that demur next, and then finish with the Lands Commission demur and arguments. And so, Mr. Walter, with respect to the California Coastal Commission's demur and motion to strike, you've had a chance to review the court's tentative ruling, I take it?
Yes, Your Honor.
Okay, so then I'll give you the first opportunity to address the court, and then I'll hear from Mr. Kinzinger.
Well, Your Honor, it was a long evening going through all of these things. And when I went through them, I compared them to the points that we had raised in our opposition papers. And I really think that I put forth our best arguments in those papers.
Okay.
Now, of course, we're disappointed in the ruling, but that's is what happens. But I think we have put forth our arguments in writing, and I don't think there's anything else that I need to add.
Okay, so you're submitting on the tentative, at least with respect to the Coastal Commission, and then we'll deal with the others in due course.
Yes.
Okay, and Mr. Kinzinger, you submit as well?
We do, Your Honor.
Okay, all right. So then the court's tentative on the California Coastal Commission's demur and motion to strike is adopted as the court's final ruling. We'll move next to the Water Board. And so, again, Mr. Walter, I'll give you the first chance to address the demur with respect to the State Water Resources Control Board, or are you submitting on that one, or did you have some additional comments that you wish to make?
I really thought that I had, when I looked at everything, that I had said what I needed to say in the papers.
Okay,
That was my feeling, and it's always nice to embellish a bit, but I'm not certain that it would be helpful.
okay, all right, thank you. And then Mr. Katz, you submit as well?
I do, and just ask for clarification as
Sure.
well. I understand the tentative, I presume will become the final. We'd like to have a proposed judgment in addition to the order. Be happy to prepare it, share it with counsel for the petitioners for comments on form and submit it to the court if that's
Yes,
agreeable.
yes. And Mr. Kinzinger, the same with for the Coastal Commission?
Yes, Your Honor.
All right, yeah. So then with respect to the State Water Resources Control Board demur, the tentative is adopted as the court's final. Counsel for the respondent is ordered to prepare notice of the order and also propose judgment.
Thank you, Your Honor.
And then finally, I'll call the
Excuse me, Your Honor, I'm sorry to
Yes.
interrupt.
Yes.
So far, I've been able to identify the speakers in the courtroom because you've been addressing them before they speak. But if they're not, can I please have you give your name before you speak, because I cannot tell who's speaking in the courtroom.
Okay, we'll make that request of folks. Thank you. All right, so then we'll move next to the Land Commission's demur and motion to strike. Mr. Walter?
Well, this is the same, excuse me, the same comments. I'm sorry, Mr. Walter, yes. The same comments as before. Can I ask just a procedural question?
Sure.
It would appear as though this portion, based upon your order, of course, maybe you'll be convinced to do something else, I don't know, but it looks as though that would require a further hearing, and that therefore there couldn't be a judgment that would be entered in connection with this.
You mean with respect to the Land Commission's
Yeah.
demur? Right, well, so the tentative overrules the demur in part, right? I mean, and so, right, there would be further proceedings if the court adopts the tentative as the final. Then there would be further proceedings on the Land Commission's matter.
Would you anticipate that there would be then separate judgments
Yeah,
or a single judgment?
well, separate judgments, right? Yeah, because if I go with the tentative as to the Lands Commission, then it wouldn't be time for a judgment yet.
Right.
But I actually do want to hear a little bit of argument on this one. So with respect, Mr. Walter, to your claim that the state lands prejudicially abused its discretion in adopting the permit because it didn't, as I understand it from the first amended petition and complaint, didn't take into account the public trust doctrine. So tell me exactly what you mean when you make that allegation. In other words, how in your opinion was the public trust doctrine violated? What's your theory? And yeah, give me something more particular in that regard.
Sure. This is really, when you think of these public trust doctrine cases, our pleading is basically following Environmental Law Foundation versus State Water Resources Control Board, which is a very broad interpretation of remedies for under the public trust doctrine and the duties of, in that case, the Water Resources Control Board, to broadly address a wide range of different claims outside of the context of a typical 1094.5 type of review or something of that nature. And that, of course, that case was one where they were basically didn't even have particular remedies in mind. It was unusual in that way, and the parties had all stipulated to determine whether the court could exercise any public trust doctrine jurisdiction. The court, and of course, this is the type of case that I was modeling the pleading after. And so it's a very, very broad set of remedies, and it's not constrained by the statutory limitations of following one particular procedure if there's a necessity for some claim or some administrative process. It's very, very broad. It triggers a very broad and an open running field, so to speak. And that's what the pleading was about, largely because that's where the facts that were presented to us as the situation evolved and changed even during the period that the TRO was pending. So,
but let's just focus on the permit that was issued by the Lands Commission. Like how, just in a nutshell, how is that a violation of the public trust?
well, because it's not based on good information or sound information. There's no scientific basis for the assumptions, and there is no mitigation that's effective.
Okay, so on the mitigation issue, I think that gets back to, the disagreement that we've had before in terms of whether, mitigation for these surveys is required right now before the working group has developed and the Coastal Commission has adopted that framework, and that's what's up on appeal. So, other than saying that the Lands Commission didn't have sufficient mitigation or didn't do baseline studies, like what else are you saying should have been done with respect to the public trust doctrine?
Well, any of those studies, there should have been conditions in effect that would protect the public trust. There should have been conditions to require adequate scientific foundational evidence to exercise any of the jurisdiction. There was not. We presented new information that was not available when they did the 2013 environmental analysis. That new information was not considered. There was a duty when the new information is presented to consider it. And then there was no hearing about it. And we were particularly concerned that there be sets of mitigations that which there weren't. There are some, but there are nothing that is close to what should be required and comprehensive enough. And that's the purpose of all of those allegations. And wanting them to, once we present the new information, they don't have a good record to stand upon. They have to update the information, and they didn't do that. They had to, and particularly with state lands, we wanted conditions to be applied that would include the constitutional protection allotted to the absolute right to fish in these lands. And when there's two types of constitutional protections under the California Constitution. One is related to the general public trust doctrine and the public trust uses, and the other is this absolute right. It's applies to when there is a possessory interest of some type that is granted by the government to a private party. They have to have a reservation of the absolute right of the public to fish thereupon. And we submitted the legislative history that's in the administrative record. I think there are allegations to that effect as well. So we just don't think, and in any event, they should have had a condition requiring compliance with the statewide requirements, even if they're not adopted, even if they don't stop. These permits are good for 5 years. There's going to be, so these are all going to be grandfathered permits without any restriction or application of best practice protocols. And it's not unusual to have a condition that operates into the future. So even if you wouldn't agree with our argument concerning staying these surveys until something is done, they when they're approved in any manner, they should still reference a condition that is going to be effective during the term of that permit. And in addition, they have a duty to do good science, to get the basic fish data, the record and the record is a different issue, but the allegations are that there isn't any good science about what these effects are. And that's what we're concerned about. And that would be a very broad remedy for all of these agencies to engage in the proper research and baseline studies, before and after studies, so that these projects don't get bogged down more and more and more, and so that we actually know what the impacts are. So that's what we want them to do. We want them to include all of the Coastal Act conditions regarding marine protection. Why? Because we can enforce it as a private party. If there is a violation, in other words, if there are conditions that and these permits that they issue routinely had Coastal Act policies that had to be actually complied with, and had the reservation of the right of the people to fish thereupon subject to it, then they would have to comply with that. And if there's a violation, it's a Coastal Act violation, and the private parties, such as fishermen, like the fishermen that were up in Northern California, whose traps were run over just a few years ago, would have a Coastal Act violation that they could prosecute against the particular developer. As it happened, there was no enforcement in Northern California. Surveys were conducted and all the crab traps were wrecked, thousands of them. There was no remedy and there was no enforcement. The Coastal Commission did nothing. The State Lands Commission did nothing. And so we want conditions that are part of this particular permit, and then obviously it could be extended to all of their permit program, this entire program that requires expressly no damage to these marine resources, and actually quotes the Coastal Act policies, incorporates them as terms into the permit, and reserves the right of the people to fish thereupon. And that creates then an enforcement mechanism through fishermen or environmental groups or whoever it is when there's a violation.
Okay, thank you. Mr. Kinzinger?
Thank you, Your Honor. This is Mr. Kinzinger. Your Honor, I understand petitioner's counsel's argument to be that the public trust doctrine is not being adequately enforced because his client was prevented from submitting materials, new scientific studies to the State Lands Commission prior to its issuance of a permit. And for that reason, the only proper cause of action for that kind of claim would be a 1094.5 writ to seek review of the agency action. That brings me to the court's point in its tentative, where the court indicates that it believes the petition adequately alleges that there was not a fair trial because there was inadequate notice given to the petitioners. We may not have squarely addressed that point in our briefing as we were responding to a litany of arguments, but I would direct the court's attention to some of the allegations the petitioners themselves make on that point. For example, in paragraph 44 of the first amended complaints, the petitioners allege that they, quote, informed all respondents defendants on or before November 14th, 2023, and again before the start of the SLC hearing on December 5th, 2023, of which plaintiffs' petitioners learned less than the day before. Now, taking this in conjunction with the petitioners' allegation in paragraph 62 that they had made, quote, many prior submittals, unquote, I believe there's sufficient allegations in the petition to demonstrate that the petitioners did have notice of the hearing, actual notice. They had been making submittals of all of these scientific studies to State Lands Commission, and that they disagree with the outcome of that decision now, but that does not mean that there was inadequate notice or inadequate consideration given to their points. For that reason, we would respectfully request the court reconsider its holding the tentative with respect to adequate notice. In all other respects, Your Honor, I believe the State Lands Commission is prepared to submit on the tentative for the remaining portions of the court's ruling.
Okay.
May I reply?
Yes.
All right. No, we were in a very cooperative spirit with all of these agencies. So in November, I think is when we start submitting many materials. And we were doing all of the agencies and all of the federal agencies and state lands and the Coastal Commission and so forth and so on. And we laid it all out in hundreds of pages of submittals, not in anticipation of a hearing. We didn't know whether there was going to be a hearing. We didn't even know if there was going to be a Coastal Commission hearing granting a permit or not, because no one told us. And this was the beginning of that particular pattern where we learn of the hearing the day before that it's occurring. And for months, we've been writing and sending statements from 20 fishermen. It's all in the record. I think they've actually lodged that record. It's all in the record, talking about the bad experiences with site surveys and the impacts that occur after these site surveys. And we made positive suggestions. We said, what you people need to do, you agencies need to do, is do a comprehensive environmental review and update your data. Make sure you have adequate fishing information and species impact information and proper mitigation and the like. And it goes on and on for hundreds, I don't know, maybe 150 pages, something like that. And we submitted all of that. So we submit this in good faith to all of these agencies, and then they shine us on. And all of a sudden, one day, we find out by accident that there's a hearing the next day. So we were doing it in the spirit of cooperation.
But what about this argument that there's enough in the amended petition to show that petitioners were aware of the hearing beforehand?
We learned of it the day before, I think. I think it's reflected in the administrative record.
And so I understand.
We didn't have a staff report. We didn't have a chance to look at the file. We didn't know anything. We had no way of, it's very hard to prepare for a hearing like that when you have to present the evidence in the record and you don't know the hearings occurring, and you've been corresponding to the highest levels within the agencies in good faith for months.
So just so I understand your argument, you're admitting that there was general notice that was given, but that you didn't know about it, but that you believe that there was a requirement to notify your clients specifically because of the history of correspondence and comments that were leading up to that point. So is there a procedural rule that you're citing for the proposition that there needed to be specific notice to your clients in addition to the general notice?
Certainly in the Coastal Commission case, which we're not talking about, there would be a requirement. I'm not aware of anything. What I am aware of is that we didn't know who was applying for what. And the only reason that we learned of it was because of public announcements by the real party in interest that was receiving that permit. So we were doing just proactive work. We had no to say we had notice of that other than a day before. I mean, we learned of it the day before by accident. You know, because
I'm not disputing that. I guess what I'm trying to figure out is who bears the responsibility for that. In other words, is there a rule, if there's a rule that required the Lands Commission to specifically notice you, then that would be easy. If they didn't do that, then we would be full speed ahead with that issue on the complaint and the petition. What I hear you say is there's no rule that requires them to do that, and that there was notice to the general public way before the day before the hearing.
Well, I haven't reviewed that part of the record to know if there was notice to.
But it's in your
to
first
any-
amended complaint, I thought.
Well, we found out about it the day before, but on the other hand, we are also making constitutional allegations that, and I don't remember it offhand, the provision, but I have certainly cited it because it was our big complaint against the Coastal Commission when they approved the federal water surveys without any notice. Yeah, there are constitutional protections that give us the right to be aggrieved persons. We have the right to present under the California Constitution our objections and grievances. And we have a right to the documents, and it's in the Constitution, and I quoted it. Oh, I forget which page, I apologize, but I've quoted it at length. It was part of the amendment that I put into the petition and complaint after we learned that the Coastal Commission had granted for the permission to do these surveys in federal waters under their consistency jurisdiction 2 days after it had been issued. And then I put that into the pleading and amended the pleading after finding that under the California Constitution, it's another right we have. It's a right that a citizen has. And we have a right to their records and access to the records and knowledge. And so when we, and you know, think of any public trust concept. I mean, what, if you see someone dumping oil in the ocean, you write a letter. To us, it's about the same thing. You write a letter to the agency, and then the agency has a duty under the public trust doctrine to consider it and to respond and to be proactive, not simply to wait until, well, or not even bother telling us that they're having a hearing. And then we learn of it, or in the Coastal Commission's case, being told 2 days after they've given the permission, and we've already filed our motion and our paperwork that they've approved that.
I want to focus on the Land Commission right now, though. So, Mr. Kinzinger, if you could just tell me what type of notice you think was required and what type of notice was actually given for the hearing.
Well, Your Honor, as a state administrative agency, the State Lands Commission is subject to the Bagley-Keene Act. So as far as notice requirements, it's required to post its agendas online. I don't recall the exact number of days, 10 or 14, but it's required to post its agendas online well in advance of the meeting. And statutorily, that's generally all the notice required. And I would also point out that there's no allegation in the petition that the State Lands Commission violated the Bagley-Keene Act. I would further point out that, there are plenty of allegations in the petition that the petitioners knew, or at least assumed, that a permit would be required. So the petitioners should have known that there would be a hearing prior to granting a permit. And, further, there's allegations that they have been, again, quoting many prior submittals. They had been, submitting, multiple documents to the State Lands Commission, setting forth, what they believe the, appropriate mitigation would be, what the newest scientific studies were saying. And finally, there's the allegation, again, in the petition, that, they found out about the hearing. Maybe it was a day before, but Your Honor, we would submit that constitutes actual notice.
Okay. Well, I'm gonna take this one under submission, and we'll issue a final ruling in due course. So we do need to.
Your Honor, I
Yes.
apologize. I wanted to chime in on behalf of CSA because we are subject to the first cause of action and we joined in the state lands demur.
Yes, go ahead, Ms. Shameless.
Thank you, Your Honor. I apologize. I just wanted to make sure we didn't conclude the proceedings before I had the chance to speak.
Sure.
In our joinder, we did request that CSA be dismissed from this action, and the opposition points out that the only alleged wrongdoing by CSA was to refuse to agree to a non-existent moratorium. So we're essentially being sued and being dragged through this lawsuit for the fact that we applied for a permit that other applicants applied for. There is absolutely no evidence, and as this court noted in ruling on the preliminary injunction, that CSA is having any part in the Morro Bay project whatsoever. It is simply a permit holder and is being sued for being a permit holder. The court found in its tentative ruling that the state lands did not abuse its discretion or exceed its jurisdiction in issuing CSA's permit. And we would ask that the court amend its tentative to dismiss CSA from this action because it's being forced to incur attorney's fees for truly no reason other than applying for a permit.
Okay. Did you wish to be heard on that, Mr. Walter?
Yes, this is Mr. Walter again. The reason that they were joined is because they made public announcements that they had received a permit and they were going to be using those permits for offshore wind survey work. And they made those public announcements twice. Otherwise, we wouldn't have known what they were doing or if they had any involvement. We're the ones in the dark. We don't know who is doing what. But we do know that they got a permit, and we know that they made public announcements that they were going to be using them for offshore wind projects. And we knew, of course, that we had talked, rather written to the State Lands Commission wanting conditions in these permits to protect and make enforceable the Coastal Act policies. And also to have the constitutionally required reservation in the permit concerning the absolute right to fish thereupon. And that's what we wanted. And that's all that we would want from them.
I guess the question is, if the court adopts at least that part of the tentative that says, there is no requirement for an out-of-state corporation to specially register in California before applying for a permit, what cause of action remains with respect to CSA?
It has inadequate conditions attached to the permit. We asked for conditions that be placed in those permits. We made that request to the state agency issuing the permit. They held a hearing, they didn't do it.
Okay, so that goes back to the prejudicial discretion argument. So if that argument, if the demur to that is sustained, and the only thing we're proceeding on is the fair trial claim, then you would agree that CSA would be dismissed, right?
That it would be dismissed from what?
Oh, well, what cause of action would remain against CSA?
Well, I would suppose, I've been pondering that, but
Well, now's your chance.
I would suppose that the fair hearing would require setting aside the permit and having a new hearing. And then we would have a new administrative record and new arguments and conditions and so forth and so on, and a pile more of hideous information and scientific studies. That's what would happen. We could have a fair hearing. We probably would get notice of that hearing. We could probably attend. We could probably, we've sent them thousands of more pages of
No,
studies.
And I understand that's what you're asking for. I guess
Yeah.
the question is, why does CSA need to be in the case for that
Well,
to
because
happen?
they're a necessary, unfortunate necessary party. If we were just suing, otherwise they could have the permit with no conditions that we think should be in the permit. But they're a necessary party if they're not joined. I mean, that's a big mistake that you probably see all the time in the land use cases where you don't join the real party in interest and,
Right.
boy, it's dismissed.
So, Ms. Shamos, why if that survives, why wouldn't CSA stay in the case as a real party in interest? I mean, it doesn't you're not saying you should be treated any differently on the arguments than the Lands Commission, correct?
Correct. However, Your Honor, the difference here is that the Lands Commission is approving permits, and this lawsuit applies to Morro Bay. And there is absolutely no allegation that CSA, as one of the numerous permittees, as State Lands stated in its demur, is doing anything with respect to Morro Bay. So it is simply an applicant for a statewide permit who received a permit, is not involved in surveying in Morro Bay, is not contracted for surveying in Morro Bay. This was established in the opposition to the preliminary injunction. There was a declaration submitted. And even if they were to get notice, the court has already found that State Lands did not abuse its discretion and did not act in excess of its jurisdiction.
Well,
So,
I haven't done that yet, but if I do, what you're saying is that you're in the same position as State Lands. As I understand it, the geophysical survey permit that was issued to CSA is allowing the surveying that's at issue in the petition. And so I don't understand why you wouldn't stay in as a real party in interest if the State Lands Commission stays in some respect, the government agency that issued the permit.
and I understand the position with respect to the real party in interest. The concern I have here, Your Honor, is that CSA is not there. There is no allegation in the complaint that CSA is actually undertaking any such surveying. There is no, it has been established that it is others who are doing the surveying. CSA has not been contracted for this work. CSA is not doing any work in Morro Bay. It is unclear why CSA is being targeted specifically as one of many applicants for this permit.
Because
throughout
you're the
state.
permit holder.
We are not the only ones.
I'm sorry?
We are not the only ones, as indicated in the.
Okay,
May
All right.
may I comment too?
sure.
Mr. Walter again. They went to the city of Morro Bay asking for dock space to conduct surveys. We
But
didn't
she's saying CSA didn't.
We have city evidence that they went there wanting to use the T-pier for the site survey work for the wind farms. Now, do we know anything more than that? No, but we do know that when they go to the city and ask to use commercial fishing space, that's a violation of the Coastal Act, unless you can make findings that that space isn't necessary for fishermen. That's why they got sued. They announced it and they went to the city trying to get space. And why were they asking for space? To do survey work for some wind company. Now, beyond that, we don't know anything.
Okay.
But it's not just a whim and a perchance that it happened.
All right. Well, I'll take that under submission along with the general ruling on the state lands demur and motion to strike. We should, just from a case management perspective, check in to see when we need to schedule something if something's not already on calendar. So. Let's see. Why don't we schedule to come back then for a case management conference? Maybe at the end of next month? Does that make sense? That way you'll have the final ruling and we can decide based on that what, if anything, remains and plan moving forward from there. I would suggest, let me see if June 25 works for the court. All right. I was looking at June 25.
Your Honor, I would be available on the 25th. I would not be available from the 6th through the 23rd if I get to have a family vacation this year.
Oh, that's fine. We want to accommodate that, and I'm actually going to be out for the next couple of weeks as well. So June 25 would work for you, Mr. Walter?
Yes,
Okay.
I'd have trouble filing some statement from Italy, but
I mean, I don't mind putting it out further either. I'm happy to go out to July 2. The next
be-
week, does that work?
that'd be wonderful. Thank you.
Works for me, Your Honor.
Mr. Kinzinger as well?
Yeah.
Okay. So then, further CMC, July 2 at 9 a.m. And notices waived on that?
Yes, Your Honor.
Yes, Your Honor.
Okay. And then I'll wait to look to receive the notices of the rulings in the other two motions and the judgments. Those should be coming in shortly, I presume. So,
Yes, sir.
anything else then for today?
No, Your Honor.
All right. Thank you, counsel.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.